He's finally been served after all of his dodging and fake addresses. Dick Luthmann is in another federal case in Florida right now for witness intimidation, defamation, and with the collaboration of their legal team, the plaintiffs, we got him served right there outside of the courthouse. He's in court right now, and when he's on the stand, this is day 2, all he does is plead the fifth or say, no, this is reporter privilege. He won't answer any questions, and yet he's online saying he's going to destroy this other plaintiff. And even me. Remember when Deuce was their savior? And he's destroyed everything. His own credibility, his own business, his own law practice. And he's not out by any stretch of the imagination, even though this anti-team has brought other haters in. The counterclaims are going to be epic. Repeating known defamation. Rebroadcasting known revenge prong? Okay, it's an adult activity. You can put the words together with the letters. Let's spell it backwards. N-R... Wait, hold a second. I'm not good with letters. As we speak, adults are playing a child's game and deleting evidence, information, videos, messages. That's called spoilage. And that, my friends, is illegal. Who's the next to be served in this real-life Garbage Pail Kids story? Well, I could tell you, it's probably going to be a Target. You know, Cheeseland. I love Wisconsin! He's finally been served after all of his dodging and fake addresses. Dick Luthmann is in another federal case in Florida right now for witness intimidation, defamation, and with the collaboration of their legal team, the plaintiffs, we got him served right there outside of the courthouse. He's in court right now, and when he's on the stand, this is day 2, all he does is plead the fifth or say, no, this is reporter privilege. He won't answer any questions, and yet he's online saying he's going to destroy this other plaintiff, and even me. Remember when Deuce was their savior? And he's destroyed everything. His own credibility, his own business, his own law practice. And he's not out by any stretch of the imagination, even though this anti-team has brought other haters in. The counterclaims are going to be epic. Repeating known defamation. Rebroadcasting known revenge prong? Okay, it's an adult activity. You can put the words together with the letters. Let's spell it backwards. N-R... Wait, hold a second. I'm not good with letters. As we speak, adults are playing a child's game and deleting evidence, information, videos, messages. That's called spoilage. And that, my friends, is illegal. Who's the next to be served in this real-life Garbage Pail Kids story? Well, I could tell you, it's probably going to be a Target. You know, Cheeseland. I love Wisconsin! He's finally been served after all of his dodging and fake addresses. Dick Luthmann is in another federal case in Florida right now for witness intimidation, defamation, and with the collaboration of their legal team, the plaintiffs, we got him served right there outside of the courthouse. He's in court right now, and when he's on the stand, this is day 2, all he does is plead the fifth or say, no, this is reporter privilege. He won't answer any questions, and yet he's online saying he's going to destroy this other plaintiff, and even me. Remember when Deuce was their savior? And he's destroyed everything. His own credibility, his own business, his own law practice. And he's not out by any stretch of the imagination, even though this anti-team has brought other haters in. The counterclaims are going to be epic. Repeating known defamation. Rebroadcasting known revenge prong? Okay, it's an adult activity. You can put the words together with the letters. Let's spell it backwards. N-R... Wait, hold a second. I'm not good with letters. As we speak, adults are playing a child's game and deleting evidence, information, videos, messages. That's called spoilage. And that, my friends, is illegal. Who's the next to be served in this real-life Garbage Pail Kids story? Well, I could tell you, it's probably gonna be a Target. You know, Cheeseland. I love Wisconsin!
Okay, here I am. I'm here today. And so I told everybody I was going to come back today, and we're going to talk about the case called Fed 2, which I'm the only one left in Fed 2 except for Michelle Preston, but she is not even, it stayed because she's in bankruptcy. So I'm the only person that's actively on the case. So I'm going to basically put something onto the screen right now. Let's see, let me get this on here. How do we add this to the stage? Let's go like this. Here we go. This is the docket sheet in the case. And why this docket sheet's important is this is the most recent stuff that's been filed on the case. And just to give everybody some understanding, because I know that Shizzy No Nuts started talking about this filing last night, and he has no clue about context. So I'm going to give everybody the context. If you see up there on 416, it says second motion to amend correct. Okay, that's when Jeremy Hales, he was supposed to do it in early April to amend his complaint in this case, to do a third amended complaint. It was supposed to be early April, but he failed. So all of the other defendants got dropped from the case. And that happened last week where the judge put in an order. But if you look at the date on that, 416, under the federal rules of civil procedure and under the local rules, local rule 7 of the Northern District of Florida, you have 14 days to respond to a motion. And so that would be by tomorrow, right? So 14 days from that would have been the 30th of, actually today would be today. So today would be the 30th. So it would have to be in by today at the courthouse, the opposing papers. So what Judge Hinkle did is he made an order on this on 427. He jumped the gun, right? He jumped the gun and didn't give me the time that I needed to, or I was entitled to respond. He took something that I had filed in the court that wasn't related to the motion. And I didn't say it was related to the motion, but on 421, which was prior to me receiving the motion by mail from the court, right? I didn't know that this motion was filed because it didn't get mailed to me. It didn't arrive till the 22nd. I had previously sent that notice of filing, right, from April 15th. That was the day before the motion was filed. Okay, that it was filed. That was the meet and confer session, and that was sent to Judge Hinkle and put on the record because he already put an order in place that said that I, Rich Luthmann, it will not end well for me if people keep on emailing the judge. So the judge threatened me, and then he basically said, okay, you don't email me. So I put it on the record. This is how you're supposed to put things on the record. It was relevant to the case, relevant to the professional conduct of Randall Shockett. And then I was going to use that evidence relevant to the motion when I filed my motion response. Well, this guy jumped the gun, and that's where we are in this case right now. We're in the situation where I'm going to go through my submission that's in with the court where this guy jumped the gun. And let's take this off. And we'll add this one to the stage. There we go. So this is what we were talking about. And I read a bunch of this yesterday, but we went to the preliminary statement. I'm only going to do the first part of this because today I'm going to talk about not only the Hales case, but if you saw the introduction that we just put on, it shows that's what's called the smoking gun. And that smoking gun shows that Hales is connected to a guy named Danesh Noshirvan. They're both mega influencers. They're both cancel culture villains. And this episode is going to show the link between the two. We're going to go for about an hour and 15 minutes, maybe a little more if we're having fun. But I do want to have everybody's comments. So we have a lot of comments on the screen. So let me start putting people's comments on there because the comments aren't on. Now they're up. Okay, good. Let's see what people have been saying. Okay, people are saying hello, little bit. Hello, little bit. Hello, Helen. Joey Camp. Hello. Who's up? Said, oh, I like this one. That's Big Dick Luthmann to you, Jerm. That's a nice one. I like that one a lot. All right. Okay, what do we got going on? Oh, here we go. We have who's this now? Terry. Who's Terry? Poor guy is delusional, doesn't realize he lost his case. That poor guy is gotta be Jerem Hales, because that video that we put up before is the smoking gun in the case. it's like so usually you have to go to Discovery and get a smoking gun. That's, oh, there's Helen. Thank you for not looking at him anymore. Yeah. I'm sorry I had to let you look at it for that long, but it's that important because that's going to be the most important piece of the evidence we have in the case. Who else do we have? We have Susan. Hello, Richard. Hello, Susan. How are you? And who else is here? We had a bunch of other people here. So what we have going on with this is the preliminary statement. And what I want to do is I want to give you enough from this motion, and you guys can read it. It's already been put up in my journalism in Florida Gulf News, flgulfnews.com, also at luthmann.substack.com. You can find all the Jeremy Hales stuff there, and you can find these documents if you want to find them. I'm going to give you what you need to know, basically, and I'm going to give you what the other people don't tell you. What Megan and Tug and Coop and all these other people, Shizzy No Nuts, J Jip, the whole bunch of them. I'm going to tell you what's really going on here. I'll tell you the actual behind the scenes and what they're thinking. So, preliminary statement. This is what you put in a motion in order to let everybody know what's going on. And if you want to see, my preliminary statement was written for about 4 or 5 pages, only because I want people to be able to read that preliminary statement and not have to read anything else. That's why I did it this way. It's like an executive summary. I didn't call it an executive summary, but that's really what it is here. It's if the judge can read the first 4 pages and he knows what's going on, he can skim the rest, or anybody else can too. So defendant Richard A. Luthmann Jr. appears especially pro se and without a waiver of any jurisdictional, service, procedural, contractual, or merits-based defenses. This means I'm showing up here. I'm making a special appearance. I'm contesting jurisdiction, and I'm reserving all my rights, including all my defenses, against Jeremy Hales' case against me, which for people who don't know or just tuning in, is a case about, he said that I published revenge porn under the Florida statute that you can sue for somebody that released intimate images of a former partner. Okay, the motion is not a general appearance. It is a threshold application to restore procedural regularity after the court granted plaintiff leave to file a third amended complaint before defendant's ordinary response period had run, before defendant's service and personal jurisdiction objections were adjudicated, and before defendant was afforded a meaningful opportunity to file a substantive opposition or Rule 12 motion. The procedural posture, matters. The court has already made clear in this case that parties are not to communicate internally with chambers. That's true. The judge issued an order. It's not going to end well. He's going to throw you all in jail. The local rules separately provide that the request for court action must be made by motion or filing, not by letters or emails to the judge. After prior informal communication, the court warned the parties that continued violations could result in serious consequences that, if the practice continued, it will not end well for them. In light of that directive, the defendant did what the local rules required. He did not email chambers. He filed a notice of filing to place the conferral defect and related correspondence on the docket, preserve the issue, and create a reviewable record. And so what this is, so people can understand, before you file a motion in federal court, you have to confer, unless it's like a dispositive motion or one that'll end the case. There's a conferral requirement under the local rule 7. And so I think it's 7.1b. And so Randy Shaka didn't do that. We put it up last time where he sent a notice to me that he's basically said, I'm doing this. Basically, do you agree or not agree? And you have to respond immediately. And if you don't, too bad. Well, that's not what it's supposed to be. Conferral is supposed to be somebody picking up the phone. I actually have another case right now in Florida where I'm suing in the Middle District of Florida, and the defendant is the Department of Justice. And I'm suing under FOIA, which is the Freedom of Information Act. and I'm trying to get records as a journalist. And I got a call yesterday from the United States Attorney, an assistant United States Attorney in the Middle District of Florida. And he called me up and he said, "Mr. Luthmann, how are you?" I said, "I'm doing great. How can I help you? I need a little more time to answer. We have your case here, your FOIA case." And I said, "Yeah, sure. I have no problems. We have no problems with service and everything else. So everything is good. You're not contesting any of that." "No, we got no issues with service. We just want a little more time." I said, "How much time you need? You need June? I'll give you June. Tell me what day." He's like, "I don't even need that. I'll take a couple of weeks. I'll put it up with the court and we'll all be good." Great. That's what a gentleman does. I had a gentleman call me from the United States Department of Justice, an assistant United States attorney. That's what's envisioned by meet and confer under the court rules. People behaving like civilized people. Now, I try to behave like a civilized person, but for certain reasons, sometimes I don't. And that's been documented, well documented by Judge Jack Weinstein and others. But attorneys always have to act in a civilized way. And the fact of the matter is, we have two attorneys we're going to talk about today. One's named Randy the Pocket Rocket Shockett, and one's called Nicholas Chiappetta. And both of these guys are in a situation where they don't act the right way. They're very, very bad lawyers when they want to, try to behave. They don't behave very well. And so that's what this is about. This is about me putting onto the docket the information there that was both violates the court rule, but also shows about bad ethical conduct. And so I'll get back to reading. The filing was not a merits brief, was not a general appearance, and was not intended to waive any jurisdictional or Rule 12 defense. The notice itself states the defendant filed it specially without giving jurisdiction, and so without waiving jurisdiction, service, and procedural or merits-based objections, and for the specific purpose of presenting the April 15th correspondence concerning Local Rule 7.1b. The problem is that the court's April 22nd or 23rd order, that's Judge Hinkle, the Article 3 judge, Judge Hinkle's order. That was what happened last Friday. That's why Lisa Lee and Robbie Kesey and Super Dave and Ray Bowles, everyone was so happy last week. They were all happy last week because they were, doing what they were doing because they're out of the case. Well, that's what Hinkle did. He has a problem with filing motions, not telling the defendant or conferring in advance because he has to cheat to win. Helen, your lips to God's ears. That's what the truth is, man. Lady, that's what the truth is. That's how he rolls. So the problem is that the court order appears to have treated the limited notice as a, quote, response to plaintiff's motion for leave to amend. The order says that Mr. Luthmann responded, UCF at 185, inappropriately attaching an email to opposing counsel rather than simply filing a response with the court, and then granted leave to file the third amended complaint. So he's like, "Oh, you did this. Screw you. That's your answer. Screw you. That's your response." No, it's not my response. I get 14 days, and that wasn't it. The judge is showing, in addition to other points, and a pattern of that he doesn't like me. But the reasons why he doesn't like me are, I think, biased reasons and based on my abilities and prior court rulings in the Eastern District by Judge Weinstein. I put myself in a bit of a protected class. So we have to worry about this with the judge going forward, whether he's not sympathetic. But we'll get that where we have to get to. But respectfully, clarification is required. That's what I'm asking for. I'm asking for clarification. Defendant was attempting to comply with the court's prior command not to email chambers by using a formal docket filing to bring a local rule defect to the court's attention. The defect is Shockett didn't email and he didn't confer correctly. He emailed and it was a notice. It wasn't a conferral. If the court intended to deem that notice a full merits response, defendant respectfully submits that such treatment would convert a procedural preservation filing into a forfeiture trap. That is not what the defendant filed, and it is not what the federal rules require. The timing confirms the problem. Plaintiff's motion to leave amend was filed April 16th. The court granted it on the 23rd. Local Rule 71E ordinarily affords 14 days to oppose a motion, and Rule 15A3 of the Federal Rules of Civil Procedure affords 14 days after the service of an amended pleading to answer or otherwise respond unless the court's orders otherwise. Defendant's notice was filed to preserve the conferral issue, not to brief futility, service, personal jurisdiction, subject matter jurisdiction, arbitration, First Amendment defenses, or pleading defects. And there are a lot of those defects. This is a whole defective Third Amendment complaint. We talked about it yesterday. A pro se defendant who obeys the court's instruction not to email Chambers should not lose his opportunity to be heard because he placed the relevant correspondence on the docket rather than sending it informally to the judge. He says, I don't want anything from you. You're going to go to jail if I send it. I file it with the court as a notice of filing, as you're supposed to do to preserve it. And then he says, screw you on your motion. That doesn't make any sense, and this judge has to review it. That's my opinion. And actually, as we do this, I want to show everybody something from the docket real quick. This is actually very important here. And you see what happened. I filed this, right? They filed the third amended complaint a couple days ago, right? And then yesterday, or 2 days ago, what they had in on the 28th was notice of non-consent to magistrate jurisdiction. So that says I'm going to the Article 3 judge. That's Hinkle. That means Bolitho can't hear most stuff. And if you see what happened on this entry right here, 429 yesterday, the motions are no longer referred to chambers of Magistrate Bolitho. Motion per chambers action is sent to Judge Hinkle. See how it goes to Hinkle below there? Referred to, action required by district judge. Chambers of Robert Hinkle notified that action is needed for 191 reconsideration. So this case is actually in front of Judge Hinkle, and Bolitho is not going to be the one to look at this. And so that's something of some importance, only because I think that they believe that Bolitho was going to get this motion, right? I think that maybe Hales and company believe that Bolitho was going to get the motion. So let's do what we have here. Let's put this back and start reading. Okay. The motion, therefore, asks for modest rule-bound relief. That's all this is. It's relief. Defendant does not ask the court to hold that local rule 7.1b has been erased, for the case. Nor does the defendant ask the court to turn every every motion filing into a new notice of intent to file. Every future motion into a notice of intent to file exercise. So I'm saying, what are we doing going forward when this guy wants to send me notices to confer? And we'll do so in a second. He sent me another one. He's like a moron. Jeremy Hales' lawyer, Randy Schock. And we're going to get to that. That's actually breaking. I'm going to show this here for the first time. The cleaner point is narrow. If plaintiff's April 14th email was determined sufficient for purposes of the motion for leave, then the court should clarify whether that was a one-time exercise of discretion or a reciprocal case management rule. But defendant's forthcoming Rule 12 motion does not require conferral anyway, if it would determine the outcome of a claim. Local Rule 7.1d exempts dispositive motions from the conference and certificate requirement. Defendants anticipate a Rule 12 motion raising lack of service, lack of personal jurisdiction, lack of subject matter jurisdiction, and failure to state a claim is dispositive as to the only claim asserted against him. So I want to file a Rule 12, I think. I don't know if I'm going to answer and counterclaim right off, or I might file a Rule 12. I'm trying to still decide. But the judge needs to tell me what's going on with these conferral things going forward. Do I have to confer with this guy anymore? The threshold jurisdiction issue remains live. Granting leave to amend did not decide whether the defendant had been validly served or whether this court had personal jurisdiction over him. Rule 4 is not a technical ornament. So I was never served. I've been saying this from day one. I've never been served, right? So it's not, Rule 4 is how you get served. They have to serve me under Rule 4. He has the burden of showing how under Rule 4 of the Federal Rules of Civil Procedure I've been served. It's not a technical ornament. It is the constitutional doorway through which the defendant is brought within the court's authority. This is a matter of fundamental due process. You cannot be brought into a court unless you have actual notice of the proceedings. He's never served me. Therefore, the proceedings against me are a legal nullity. Okay? Defendant sustains or maintains that plaintiff has not properly served him and that the court lacks personal jurisdiction, absent valid service. That's basic law. Okay, those objections should be briefed before the defendant is required to litigate the merits of a newly filed pleading. The amendment is also futile to count 2, the only claim now asserted against Luthmann, because it involves Florida's sexual cyber harassment statute. That's Florida statute 724.049. But the third amended complaint does not plausibly allege that the statutory core, a real private sexually explicit image of plaintiff published contrary to plaintiff's reasonable expectation that the image would remain private. So he's got to tell me what the image is that is a sexual image that was of him, that was a private image that he had an expectation of privacy in, and that it didn't remain private. What's going? He's telling me that, and we did this yesterday. That third amendment complaint, that there's an image and it's his likeness and it's this and it's that. He never says it's a sexual image. He never says it's a private image. He never says he has a reasonable expectation of privacy in the image. He has all these defects in his pleading to begin with. Why do I have to go and talk about that stuff? Okay, but instead, the pleading describes public online satire or mockery. It labels it unlawful and adds conclusory assertions that lack legitimate purpose or newsworthiness. He said it's not newsworthy. It's not this. It's not that. It's not satire. He's a moron, basically. Everybody knows that this guy is a moron. Both his lawyer and him. Jeremy is a lawyer and the lawyer. The lawyer is pretty dumb for writing this thing out this way. But there's a very famous case. There's two famous cases called Bell Atlantic versus Twombly and Ashcroft versus Iqbal. That's Twombly and Iqbal. Some lawyers call it Twickbal because they put it together. And that's the Rule 8 pleading standard. And he didn't meet the Rule 8 pleading standard, is what I say here. He doesn't specify what's going on enough for me to be able to answer it. And next, it also raises serious First Amendment concerns under Hustler Magazine Incorporated versus Falwell. That's the 1988 case. And it basically stands for the very important proposition: parody, satire, and commentary on public controversy cannot be transformed into actionable emotional distress liability merely because the target claims offense. And we talked about it yesterday, Hustler Magazine versus Falwell, right? We talked about it yesterday. Jerry Falwell had it was in a Hustler Magazine satire by Larry Flint, and he insinuated that his first time sexually was in an outhouse with his mother. Right? It gets all the way to the Supreme Court of the United States, and the Supreme Court says you can't sue Jerry Falwell. You cannot sue Larry Flint because that is satire. You're a public figure. It had some value in the satire value. And if we say it doesn't have satire value and allows you to sue, then there's no First Amendment anymore, because people like Germ could turn around and sue everybody that says anything about them that they dislike, right? And we've seen that already. He's already done the activity that in Hustler Magazine versus Falwell, the Supreme Court said we don't want to allow. Okay, so here we are. We have the First Amendment issue. That's after we get to the first issues of service, jurisdiction, the issues of pleading and sufficiency, and the issues under that Florida statute. And what I'll do is I will actually show us. We're going to do a quick little break and show us a case that actually came out a few days ago, actually earlier this month. Let me share this tab right here. And this is the Volokh conspiracy. All right, this is Eugene Volokh, the professor. He's a law professor. He's a very smart man. He clerked for Sandra Day O'Connor. And this is about Megan Thee Stallion's request for an anti-cyber stalking injunction against online defamer denied as a prior restraint. Okay, now this is how important the First Amendment is. This person, okay, was defaming Megan Thee Stallion. There's no question about it. This person is I believe he made a sexual, a fake sexual video, a real fake sexual video. It shows Megan Thee Stallion as naked, shows her private parts, shows her doing stuff, and puts it online, okay, and stuff like that, and other insinuating stuff and things like that. So they said, look, here's what the judge said. Plaintiff is allegedly the target of hurtful, angry, offensive, humiliating, racial, and gender-based hate made an online post by defendant's followers. As tempting as it is to force some civility into the matter by staunching defendant's speech against plaintiff through an injunction, doing so would ignore the protections of the First Amendment. That's very important here, because this is a Florida case, Southern District of Florida, Florida federal court case. And so I'm not going to get into this whole thing, but you have a situation where the jury awarded defamation claims against the defendant, $75,000 defamation, promotion of an altered sexual depiction in violation of Florida statute, intentional infliction of emotional distress, but also asked the judge for a permanent injunction based on the alleged cyber stalking. Okay, so they had all this stuff and tell the people to take it down. This stuff. Well, the basis of this whole article and the basis of this case writes that Judge Cecilia Altanaga in Pete versus Cooper in the Southern District of Florida said is, even though they found after a jury trial that there should be some type of reward given under the statute, they still cannot give a restraint on speech. So what Jeremy Hales has in that case, and I didn't put that actually up, so I have to put that up. Let's see. Let's put that up. Let's see. Let me add it here. Let me undo this, and then we'll put up this one. And we'll put up. This is what I thought I was sharing it, but I didn't share it. So let's go share. Does everybody see that? Is that seeable by everybody? Okay, good. This is the case, Megan Thee Stallion. Okay, and Megan Bearded's here. Hey, Bearded, how are you? So everything is doing good now that Bearded is here. The Bearded is making everybody's lives a lot better today. That's good. So what we have here, Megan Thee Stallion's request for an anti-cyberstalking injunction against online defamer denied his prior restraint. Even though this guy they got 75,000 against this guy, right? It's still no good. You cannot do an injunction. And Jerm is still asking for injunctive relief and all this other relief that he can't get. Plaintiff is allegedly the target of hurtful, angry, offensive, humiliating, and racial, gender-based, and hate media and online posts by defendant's followers. As tempting as it is, will force some civility into the matter by staunching defendant's speech against plaintiff through an injunction. Doing so would ignore the protections of the First Amendment. So this shows that the First Amendment is operative here. And everybody has to recognize that the First Amendment is operative here. And so we'll go back to what we're talking about. Okay, and that's the backstop here. I know that I'm going to win, and Jeremy's case is going to go out on the First Amendment issues, but my question is, do I want to have fun with him first? I'll win on a Rule 56, which is summary judgment, but I probably can get all my discovery done before that and get a whole bunch of his materials and then have plenty of content. I'll go on every day like this. We'll go on for like an hour and a half and talk about what the next thing about Jeremy is. That could be a fun thing for me to do. I got nothing better to do, right? I love everybody that's on this stream, all these people, everybody that wants to see about the germ. But we're also going to talk about Danesh next, and I'm going to be doing stuff with Danesh. Defendant also requests limited procedural solicitude consistent with the pro se status. So this part is about the fact that they get everything by mail. I get everything 4 or 5 days later by mail. They send it up in Gainesville or up in Pensacola, wherever, and then I don't get it for 3, 4, 5 days because I'm all the way down in Southwest Florida, down in Naples, right before you get into the Everglades. So that could stop a lot of me filing. It'll stop a lot of shock and filing if I just got a notice, an email. So defendant asks for liberal construction of his filing, leave to file proper merits opposition to the Rule 12, and an order requiring proper service plus courtesy electronic copies to richard.luthmann@protonmail.com. That's my email address. I'm a journalist. I get my email there. If they send me that email, it's I take responsibility for it, but they don't send it there. So it delays everything. The accommodations does not alter the federal rules, doesn't grant ECF privileges, doesn't prejudice plaintiff. It simply reduces confusion as to where the court has already forbidden informal emails to chambers and where pro se paper service delays can create unnecessary disputes. This whole thing, I think a lot of it is because I'm getting paperwork in the mail. And I deal with the paperwork when I get it like it just happened, but it happened days before, and there's stuff on the ECF. So I don't even know about it because I don't get it until I get it from the mail. The uploaded research memorandum correctly identifies this as the strangest or as the stronger, safer, rules-centered path. That's what I want. I just want fairness here. Let's make some fairness. For these reasons, the family respects that the request clarification or reconsideration of the April 23rd order leave to nunc pro tunc. Now for them, that's Latin. Nunc pro tunc, now for them, to file a full merits response Rule 12 motion, preservation of all jurisdictional service defenses, reconsideration and leave to amend if the court reaches futility now. So I want the court to see if there's futility and then say, you know what, you never should have amended. This is a futile claim, and such other further relief as is necessary. Okay, then we go to the background section. I talk all about the background. And that's not, if you want to read it, it's interesting stuff in there. But the whole point is, what is this court doing? Now, the other thing I did file, and what we saw is that I filed a note for the Article 3 judge to look at this. And the Article 3 judge has to give an order. Bolitho made an order, but now this, because I filed that, no consent to the magistrate judge, the orders have to go back from Judge Hinkle. And the motion's taken out of Bolitho's hands. So we'll see what happens. I'm going to be prepared to file within the 21 days Bolitho said, but we'll see. The judge might dismiss the whole thing. He might give me more time. He might allow me to put in a response to the amendment, thinking that that's futile. There's a lot of things that judge can do. Now, what's the next part about this? Okay, let's remove this from the stage and show this right here. This was filed in the Northern District in Fed 1. Everybody knows about Fed 1, and we have a guy named John Cook. I think John Cook is here today. John Cook, are you here today, John Cook? How you doing, John Cook? And John Cook is here, and there he is. So, John, this is what you filed in the court the other day, right? And so it's very, very basic. They made the case go forward against Rich Luthmann in Fed 2, even though Michelle Preston is in bankruptcy and there's a stay. But they made the case stayed against John Cook. So it's two people. Me and John Cook are in the same spot. We're both in a case in the Northern District of Florida. We both have a co-defendant that's in bankruptcy. My case goes forward while the co-defendant's case is stayed. His case is stayed while the co-defendant's case is stayed. Does that make any sense? Right? So that's part of the issue. But this part is an important part right here about attorney Randy the Pocket Rocket Shockett. Okay? The Pocket Rocket Shockett. And so, we're going to show you, I'll show you a picture of Randy Shockett. Everyone want to see a picture of Randy Shockett? I got a picture of him right here. This is actually a picture. That's him looking as charming as a serial killer. Randy Pocket Rocket Shockett of Trenton, Florida. That's him right there. Looks like he wants to, chop out your organs and make him into a hamburger or something. That's what that guy looks like. Well, anyway, we have the John Cook thing, and he doesn't like Randy Shockett. Randy Shockett is, it's just a pattern. I guess it's not just me. John Cook requests the court order attorney Shockett to show cause why he has suborned perjury by filing his client's affidavit containing the false statement that Mr. Cook and Mr. Preston's online posts calling me a child predator are constant and ongoing to this day. There are no such posts. They have not produced any such posts. Tens of thousands of people follow the case on YouTube as is the O.J. Simpson trial. My former counsel publicly offered a $2,000 reward for anyone who could produce even one such post. If there were any online posts calling Hales a child predator, someone would have claimed the reward. Nobody did. Plaintiff's allegations in paragraph 19 of his affidavit was not in the complaint. It raises a red flag that it was fabricated to overcome dismissal under 12b1. Otherwise, it would have been included in the complaint. The allegation in paragraph 19 of the affidavit is far more serious than any of the statements attributed to me and Preston in the complaint itself. So if it were true, it would not have been left out of the complaint, only to be raised in response to a 12b1 motion. Attorney Shockett had an ethical duty, not to file a false affidavit. The allegation involves easily verifiable facts without first confirming the existence of online posts by me or Michelle Preston calling his client a child predator. He could not ethically file that affidavit. He did so to influence the court's exercise of federal jurisdiction. The court explicitly relied on the perjured statement in ruling that the federal jurisdiction existed. This is some heavy shit. This is saying that the only reason that Cook and Preston are in this case is because of a lie. And the lie was made by Jeremy Hales and the lawyer at the same time. The lie by Jeremy was that he was called a sexual predator by John Cook and Michelle Preston. And the lie by the falsity in the lie by attorney Shockett is even worse because he's supposed to verify before he puts it into the court. Jeremy can say something, but the lawyer's supposed to verify what he's saying is true. And they didn't show them the post. And Tina says it right here. The posts don't exist. Okay, so let me go back and finish this. The court explicitly relied on the perjured statements. The court wrote, plaintiff alleges defendants Cook and Preston have made online posts calling plaintiff a child predator. And those posts are constant and ongoing to this day. Plaintiffs has allegedly engaged in a public and coordinated campaign to ruin plaintiff's successful social media business by, among other things, repeatedly online and in the real world, falsely accusing being a rapist and a child rapist. Okay, that's what's in here. And that's the allegation. You would think that if there were posts, we would know that there are these posts by now, right? That these things, that's pretty serious stuff that's going on. But that's Jeremy Hales for you. Jeremy Hales is a very crazy person. He's out of his mind. You know, he's a mental case. I think somebody just said he's a mental case, right? He's a mental case. And who said that he's a mental case? Let's see. Yes, very dangerous. He's very dangerous. That's right. He's very dangerous. That's one. Gertie Bird. That's very dangerous. Here it is. Gertie. In my opinion, Hales is mental. I think that's, you know, that's Gertie believes it. That's something that a lot of people can believe, you know. I think that he's bigoted as well. And I talked about that in the article that I put out today, earlier today, about where the origin of paint chips. And actually, maybe we can go to the paint chips. Maybe I'll put that up right now. That might be a fun thing to put up. Let me see. Let's see how we do this. We're going to share. Let's do the screen share. How do we do the screen share? I remove this guy, right? And then I do the screen share. Present or invite. Share screen. And all right, let's see. Okay, I'm going to share something here. Okay, there we go. We're going to share this. We're on the screen. This is the story I put out earlier. If anybody's in Northern New York, it might be fun for them to look at. Or Western New York, actually, not Northern New York, but Western New York. But we did over here. Oh, they're talking about New York. Might be fun for them to look at. Or Western New York. Look, that's feedback. Okay, so then the story that we're going to look at here is the one we put out yesterday with the Florida courtroom or studio, and that's where I asked if this is a situation where this is a if this is a content farm. And we talked about all this stuff yesterday, but I put in here there's Larry Foreman. That guy is so creepy. Like, honestly, is that guy not creepy? That guy's like one of the creepiest guys ever. He's like so creepy. And so he's one of the defendants in one of the we talked all about it yesterday. He's just a creepy lawyer from Kentucky, and they concocted this thing with Preston and Cook, and it's just so stupid. This guy, he's just, you know, he's a terrible sleaze over here. Look at him. So, but in this story is at the bottom part of the story. I think I want to call to everybody's attention the most important thing, and that's part. This is one of the a screenshot of the video that they're claiming is sexually explicit material. Can somebody tell me what part of that is A, sexually explicit, and B, is something that Jeremy or his friend Megan could claim is a reasonable expectation of privacy, or even an actual picture of them? Neither of those pictures are actual pictures of the two. They're clearly photoshopped images for satirical purposes, right? So I don't know where they're going with this lawsuit. Okay, we'll talk about that, but you know, I just don't get it. You know, this is how they roll. They put this stuff in. They haven't shown this to the judge, and the judge probably hasn't even seen any of this crap yet. The judge has not seen that this is how stupid this case is. It really hasn't. So, yeah, look at Beardfist. It looks like something. Where is it? Looks like something out of Mad Magazine. Mad Magazine. It's Alfred E. Newman stuff. That's exactly what this is. This is Mad Magazine, Alfred E. Newman stuff, and I'm in federal court over it. That's the crazy part about it. But I don't care, because I'm going to have fun in federal court. I'm actually having a lot of fun so far in federal court. I'm doing streams every day. I'm talking about this every day. All right, so the next part we have, that's Megan's bedtime story, is we talk about there's the video. The video is here, too, if you want to see it, the infamous video. No. But the whole part about the eugenics and the anti-Semite. Luthmann recapped why he believes Jeremy Hales is an anti-Semite and Megan Fox is a eugenicist in the origin story of his, quote, paint chips moniker. And this is from an article. If you click on there, Jeremy Hales is an anti-Semite, and you click on that, it goes to the article. This is what Volpe and I talked about. Volpe was particularly disappointed in Fox's turn towards hate. Quote, Megan Fox wasn't like this a few years ago, he said. She used to stand for something. Now she's just another Hales groupie parroting whatever he says. And then we have this Megan Fox post that supports it. Unpopular opinion. Let the kids eat Tide Pods or nutmeg, whatever dumb thing TikTok tells them to. Let's learn if you learn the hard way rather than impose all the safety laws on everybody else with IQs higher than amoebas. Darwin Award. In my mind, that's a problem. Why? Luthmann noted that Fox and Doug also push disturbing eugenist rhetoric. These people joke about kids eating paint chips, and that's what they were doing. Tug and Megan were talking about little kids eating paint chips, and that's actually very serious because that shows that it's totally the issue in New York City, where I'm from, where I was born and bred, about the New York City housing projects. Little kids that are in the place that it's not their fault, especially little black and brown kids, eating lead paint chips. Children being poisoned. And yet this sicko, Megan Fox, and this sicko, Jeremy Hales, don't care about little children being poisoned through no fault of their own. Is that they talk about how stupid parents shouldn't have children. This isn't just a problem of anti-Semitism. This is a sickness, Luthmann said. That's 100% true. It is a sickness. They are sick people because they're talking about eugenics. If somebody is poor, and I know a lot of people that have been very, very poor in their lifetimes, that lived in the projects, that lived on public assistance, that lived in foreign communist countries that come to the United States to escape dictators and had not the shirt on their back, and they're poor. And they're living potentially in government housing for a little bit until they get out. And God forbid there was lead paint and the child had brain damage. What this sick woman is talking about is eugenics. Let the children die. Let their stupid parents die for being poor, for being refugees, for being black or brown. That's what this woman says. She's a sick woman and he's a sick person. This is a race-based situation for me. I believe that. It is a race-based situation with them. They don't like certain people. It's also a ableist situation. They don't like people that aren't them. And when you look at their little cabal, it's all of the same type. Right? It's all of the same type. So, let's see. Beardy, you say you got an echo? Am I better now? Does it sound good? If we sound good there? All right, we're good to go. All right, so I'm going to go back to what before my diatribe on everything there. Okay, we're going to talk about the next little piece. And the next piece is what I told you was breaking today. Okay? And can everybody hear?
Horse trading, criminal threats for a civil resolution.
Is that better now? Are we better? I just want to get a feedback from everybody. Okay, loud and proud. Thank you, Bud Light. Okay, I think it's because I'm still not familiar with this StreamYard. I'm on StreamYard and I just don't know how to make it work. I need like a producer. I need like Mr. Producer. I don't have Mr. Producer. So I think I need a producer. I don't know. Got to find a radio person to help me out with this. All right. So I'm going to send this over. This is an email. Okay. That was today. And we're going to start at the end because the end is always more fun. This is what I got down here. Mr. Luthmann, this is yesterday, the 29th. We intend to file a motion for ruling on our motion for expenses incurred in making service and attorney's fees pursuant to Rule 4D of the Federal Rules of Civil Procedure. Okay, so the situation here is there is Rule 4D, which says that Randy Shockett properly served me. And then before that, he tried to give me service correctly to where I live. Then he can get the costs of service, right? He wants to get the judge to say that Jeremy Hales is going to get money, all right? It's not going to happen because A, he didn't properly serve me, and B, his attempt to send a package under Rule 4D went to the wrong address. The address that he sent it to was my old address, 338 Sugar Pine Lane in Naples, Florida. My new address is on all of my pleadings. It's in Pacer, and I've lived that address for several years already. He sent it to a several-year-old address. Now, that's the first problem he has. He sent it to the wrong address. The second problem he has is until a couple of days ago, right, Until a couple of days ago, the place where I lived, according to his pleadings, was the state of New York. He sent the process server to New York. He said G-Man sent one of his people. G-Man put in an affidavit that he had no knowledge of, that he perjured. He put in false statements because he couldn't know that they were true, because he wasn't president in New York. And he said that, oh, we went to New York. We tried to serve him in New York. Well, 2 days ago, they filed the third amended complaint, and it's the first time that this court has ever heard that Luthmann lived in Florida. Well, in order to find out if Luthmann lived in Florida, all you got to do is go on Pacer. So you got Jeremy Hales' lawyer, Randy Shockett, who's a moron, and he can't even go on Pacer. He can't even go on Pacer and try to figure out what the heck is going on Pacer, right? He can't even see if Luthmann is on Pacer. And so they're going to lose this motion, but I sent this back to them today, and I'm going to read to everybody what I said. Mr. Pocket Rocket Shockett, I sent this to him at 11:50 a.m. today. I disagree with your proposed request in its entirety. It's his request for money for not actually serving me and not sending me a package correctly. He's a moron. Let's be clear. I have already rejected the relief sought, and nothing has changed. I was never properly served under Rule 4, and your attempt now to shift burden and extract expenses from a procedurally defective service effort is as baseless as the underlying theory. You cannot claim costs for service that was never legally occurred. Rule 4D presupposes a valid service waiver framework and proper notice. You failed at both. I just explained that. Then I sent them a picture. You get nothing. You lose. Good day, sir. That's Charlie and the Chocolate Factory. I love that. So failure, Mr. Shockett, is a common theme in both Jeremy's and your lives. Just ask your kids. To be clear, this is not a technical defect, right? To be clear. Oh, this is not a technical defect. It's a jurisdictional failure. This is something that's in the statute. It's statutory. You don't get to cure by, after the fact, filing motions and hoping the court fills in the gaps. You don't. And Bearded says it right. It sounds kind of intentional to me. Intentional, right? It's intentional, right? And there's Marla. She's laughing. I know Marla's laughing. And so is Mindy. Mindy's laughing too. But this is a situation, right? This is a situation. Now I'm going to tell you what it is. I say it right here. I hope this winds up in court. What this looks like, again, is the same pattern we've seen throughout this case. Motion practice, not for adjudication, but for amplification. Filing for the sake of filing and turning the docket into a content stage. This may play well on YouTube, but it does not survive even first-year civil procedure scrutiny. This guy, it's like he slept through law school. He slept through, they actually taught law in law school. He was asleep. It must have been in dental school. He must have had leftover gas from dental school. He got thrown out of Missouri dentistry, and then the Arkansas bar said no, and the Arkansas Supreme Court said no. He found a license in Florida, I guess, in a Cracker Jack box. Who knows? But I have to ask, are you all in on the What the Hales POLAMOP media strategy, or are you simply a shitty lawyer? Because those are the two things that I have here. Either he's all in on Jeremy Hales POLAMOP, he's going to make as much money as he can for Jeremy, he's going to do whatever Jeremy wants, he's not going to exercise professional judgment, he's going to break all the ethical rules, or he's just a shitty lawyer, he doesn't know the difference. He's a moron. And I think either one is in play right now. I think he could be 100% total moron. He could be one of the worst lawyers in America, given what he does. I also want to be direct about something else. His ongoing drip of fee demands paired with legally defective service and a case already riddled with Rule 12 issues looks less like advocacy and more like pressure tactics. When you repeatedly assert entitlement to money on a claim that lacks a valid legal foundation, it begins to resemble something far closer to extortion than litigation. And I don't think lawyers can be engaged in extortion. I know that for a fact personally. So you should reconsider this course before I take you and your client to the woodshed. What does that mean? If you proceed, I will respond accordingly, including seeking appropriate relief. I will get sanctions. I'll go for sanctions. He's a shitty dentist and he's a shitty attorney. That's basically what it comes down to. You know, now, this is what he put today. I don't know if the docket, I came on the air. By the time we were on the air, I don't know if he put the docket up and everything else. Who knows? Who knows what he did? But that's what we got there with that. And so that's germ what we have for today. I showed the John Cook stuff, and I showed everything else. But the next thing I want to show is something that is related to his buddy named Danesh Noshirvan. And for people who aren't here in the beginning, I'm going to play the video again because it is a public fact now. Okay. And oh, here he is, Joey Camp. He's back. Joey Camp, the one, the only. I'm going to play this video because what this video does is this links the Danesh Noshirvan litigation in the Middle District of Florida with the Jeremy Hales litigation in the Northern District of Florida. And we're going to play this right now for everybody to see.
He's finally been served after all of his dodging and fake addresses. Dick Luthmann is in another federal case in Florida right now for witness intimidation, defamation, and with the collaboration of their legal team, the plaintiffs, we got him served right there outside of the courthouse. He's in court right now, and when he's on the stand, this is day 2, all he does is plead the fifth or say, no, this is reporter privilege. He won't answer any questions, and yet he's online saying he's going to destroy this other plaintiff. And even me. Remember when Deuce was their savior? And he's destroyed everything. His own credibility, his own business, his own law practice. And he's not out by any stretch of the imagination, even though this anti-team has brought other haters in. The counterclaims are going to be epic. Repeating known defamation. Rebroadcasting known revenge prong? Okay, it's an adult activity. You can put the words together with the letters. Let's spell it backwards. N-R... Wait, hold a second. I'm not good with letters. As we speak, adults are playing a child's game and deleting evidence, information, videos, messages. That's called spoilage. And that, my friends, is illegal. Who's the next to be served in this real-life Garbage Pail Kids story? Well, I could tell you, it's probably going to be a Target. You know, Cheeseland. I love Wisconsin!
So they have a saying that they can tell, the type of person you are by who you associate with, right? And that's a pretty good thing. If they see who you associate with, then, they can tell who you are. This is Danesh Noshirvan right here. Okay, this is in front of the Middle District of Florida Federal Court in Fort Myers, Florida. I'm coming out, and we played a video before, and I'll play it probably not today, but another day, about my interview or attempted interview with him and his lawyer on that day. But I'm going to play another video to let everybody know who Danesh Noshirvan is, so that everybody can know who Jeremy Hales is associating with.
The Ayatollah is paying me. That is right. We have an agenda to turn America into Sharia.
That's Danesh Noshirvan. Danesh Noshirvan is a very, very bad dude. Okay? He's a guy that's called for Marco Rubio, the Secretary of State, to be killed. He's called for ICE agents to be killed and shot. He's called for the President of the United States to be killed. And he's a sympathizer with the Islamic Republic of Iran. Okay? He's a terrible dude. And Jeremy Hales in that last video admitted that he and his lawyers, right, this guy, Randy Shockett, communicated with Danesh Noshirvan and his lawyers. And so we're going to talk a little bit about who Danesh Noshirvan is and who his lawyer is, more important than that. And that's this guy. This is a guy that Joey's on the stream. Joey Camp knows very well. And I'm going to talk about Joey Camp before we get back to Nick Chiappetta. But this is Joey Camp. Joey Camp is actually an American hero, in my opinion. I know Marlon doesn't like him, but I think he's a hero for what he did during the George Floyd riots, basically, and the billions of dollars of destruction of property, the deaths of the Kenosha in Denver and all over the place. Now, Joey went as a journalist, and he would go into the situations with Antifa. So he would dress up. Actually, he wouldn't have the American flag on, obviously. He'd dress up like one of the Antifa people. And he would try to videotape these people and discover who they were undercover. So there you go, Joey. Not a hero, but a patriot. I think that you are a hero and a patriot. I'll tell you that. But the fact is, he would do that, and he's also a journalist when he's doing this. He actually caught some really insane pictures of the riots. This is actually in Denver. This is the George Floyd riots. The state capitol's behind where they started. They're marching down the streets. They're looting property. They're burning stuff. They're taking things. It wasn't a peaceful protest that everybody said it was. It was actually, a crazy situation. And the culmination, and for people who are interested in this and the law and our system of justice, right? This is the Denver courthouse. This is the Gus J. Solomon United States Courthouse. Look at what went on here. This is 2020. This picture should be all over the place right now to understand how important it was that we don't have these people in charge of our country anymore. Look at the courthouse. You have graffiti on the courthouse. You have these armed Antifa people, in riot gear taking the place over, going to the seat of justice in our country. These are basically anarchists or people that are agitators that want to destroy, right? That want to destroy the American way of life, the American courts, the American system of justice. They want to take people that are regular, normal people and say that there's something wrong with them, okay? And this is what Joey Camp really tried to show. And this guy, Danesh Noshirvan, is one of their online mega influencers, okay? He has millions of people that follow him, and he promotes the agenda of anti-United States, the Iranian government, the Mexican cartels, the Chinese Communist Party, other people. He's totally woke, totally crazy. Worse than him, though, in my opinion, okay? Worse than him, in my opinion, is his lawyer named Nick Chiappetta, also known as the Chiappetta. And I did an article about this guy a few days ago. We did an article, my outlet, and I'm going to put it up. I'm going to see. Let me put this one up now. Let's see. Bear with me. Hopefully, there's no what's it called? Feedback. Okay. Let's see. If there's feedback, tell me so I can get rid of it. And this is what it is. This is called Nick Chiappetta's Bar Troubles Just Got Real. Okay. A federal reprimand, an active bar file, and 3 live Danesh cases now point to the same hard question. Does Nick Chiappetta face real discipline? And if so, what happens to the lawsuit? So the situation here, and the story that this is about, is this guy, Nick Chiappetta, is the lawyer for Danesh Noshirvan in 3 cases. And he's basically handling a lot of other stuff for him, including takedowns of his social media pages. Some of the social media pages, and Joey Camp knows all about it, that he puts on material that should not be on those pages. Copyrighted material. He's got an OnlyFans page, or he used to. He's got other these stream stuff. He shouldn't be doing this stuff. Okay, he shouldn't be putting this stuff on these pages. And so there's DMCA, Digital Millennium Copyright Act. Okay, and those are the notices that you put in. And when you put in those notices, the sites have to take the stuff down, and a lot of this stuff's been happening. Well, Chiappetta has been helping out with that, but he's also helping out with all the cases, and he's got his own problems. And so if his problems with the Florida bar, and I'll cut to the chase here. We'll show everybody what the problems are with the Florida bar. Here it is. Okay, this is Husani. Okay, Miss Husani. Okay. Forwarding this matter to your committee for further investigation and disposition. I will serve as an investigating member and will report to the committee when my investigation is complete. I have enclosed the copy of the notice of assignment of investigating member. What are they investigating? This is the Florida bar. They're investigating Nicholas A. Chiappetta. He's under investigation, ladies and gentlemen. He may not be the attorney on these cases if he is either suspended from the practice of law for any period of time or fully disbarred. This is a very serious situation, right? A very serious situation. And so I'll show everybody else the notice on top of that. Let me show everybody the notice, because the notice is something that you don't see every day, okay? Because this is as serious as it gets with respect to the, let's see, it's a right here. Okay, it's as serious as you get with a lawyer. This is when you have lawyers. I've talked to lawyers. I sent them this notice and say, have you seen this thing? It's like, I've never seen a notice like that before. And here's the notice, because they've never been in trouble with the bar to this extent, right? This is a notice of assignment of investigating member, right? The grievance committee will consider the matter and the bar counsel will be serving as investigating member. You see the top? In the Supreme Court of Florida, right? That is what we talked yesterday about Bruce Manskin and Robert Grobe, the judge. And the only place that could do findings of unauthorized practice of law or any type of grievances or anything like that, attorney misconduct, is the Supreme Court of Florida. Well, this is in the Supreme Court of Florida related to Nicholas A. Chiappetta of Lake Worth, Florida. This provides a notice that the grievance committee will consider this matter and the bar counsel will serve as investigating member. The bar counsel is like the prosecutor. This guy, William Mulligan. He's going to make the case that this guy committed a serious grievance of the attorney ethics. To get to this point, it's serious. And so it talks about any information, documents, respondent, when the complainants would like to consider it has already been provided to the bar, must be submitted within 10 days from the date of this notice. So that's got to be in basically by tomorrow. I sent some stuff, additional stuff in. We'll see what happens. But this is very, very serious stuff. And so what we want to do here is we want to show that show what's happening with the Chiappetta case. So let me show the Chiappetta case right now. Let's see right here. Let's put it back on the screen. We'll take this one down. And I'm still getting the hang of this stuff, so bear with me while I up and down things. So that's there. And then the screen for this is Nick Chiappetta. And here we are. That's him. Very, very sad looking Nick. And we have a thing here. I'll show this to everybody. This is a video that I made. It's a satire video, and I like to make satire videos. Does everybody like my satire videos? Satire videos are, I think they're a lot of fun, and actually they're informative because it gets people interested in something that wouldn't be necessarily interested in. And this satire video, I'll set it up. That's Bobby Brown. Does everybody know who Bobby Brown is? 10 points if you know who Bobby Brown is. First one to put it in the chat. If you know who Bobby Brown is, who's Bobby Brown? Who was he married to? Who knows? Bobby Brown. Who was Bobby Brown married to? Oh, here we go. Bearded Fisherman, I think, was first. Actually, I'll give Helen. I clicked Helen's first, but I think Bearded was first, but Helen said it too. Whitney Houston, right? Whitney Houston was one of the greatest American vocalists that there is. I don't think anybody can ever argue with that. I think her version of the Star Spangled Banner is still the greatest. And so Whitney was great, and she was a church choir girl, and she was everything, very, very everything that you wanted in somebody. She was a very good person until she met Mr. Bobby Brown. And then she met Bobby Brown, and magically, right? Magically. And there's a lot of Whitney Houston. Everybody got a lot of smart people in this group. And Helen, I think we gave Helen the award, right? I got to come up with an award for you, Helen. I'm not sure. But magically, Whitney got hooked on crack after she met Bobby Brown, right? Bobby Brown was basically, reportedly a crackhead, and he's a public figure. When you put a public figure, you can talk about stuff like that. Whitney died. There's all these different political stuff, or not political stuff, but like TMZ type stuff, media stuff, going on, and legal battles, everything else. So the situation becomes, I did a video about that because we have Nick who's breaking all the rules too, just like Bobby Brown was breaking all the rules. And he was threatened to get sanctioned by Judge Steele in the Middle District of Florida in front of the court. And this is a satire video in front of the courthouse. So let me get this video and play this video for everybody so they can see.
I kept telling Whitney to cut out the loose shit. It's a waste unless you cook it. I tell Marta the same thing. Damn, you love your paraphernalia. Let's get out of here before I get sanctions.
All right, so that's Paraphernalia Nick Chiappetta. And I want to say, I don't say this for no reason whatsoever. I do not say this for no reason whatsoever. The man actually has a paraphernalia charge. And what we can do is I can show it to everybody. Why don't we show it to everybody? This is a top secret report, right? About possible criminal records. Who's the subject? Nicholas Chiappetta, right? And we don't want to talk too much about this stuff, but I do want to show the page here, right? That has his criminal records. These are all criminal records here, right? Look at all the records here, okay? Now, this is in Illinois, Cook County Municipal, right? Okay. These are, that's a speeding ticket. That's this. Okay, misdemeanor. Okay. Here we go. Possible possession of drug paraphernalia. Look at the bottom of this page. Crime, Cook, Illinois. Possession, drug paraphernalia. Cook County misdemeanor. Oh, paraphernalia. Oh, okay. And that's what we have here. So we have all this stuff here. He has it on his rap sheet, but this is the lawyer, and the lawyer's got all this rap sheet going on. It's all this. It's about 5 pages long of a rap sheet on a lawyer. So that's what we're talking about, this guy. And so I don't know about him, especially because he hangs out, with this guy, Danesh Noshirvan. Don't know about him. Actually, we know terribly about him. But we're gonna talk about this this article because it talks about the fact that he is in a situation where he may very well be, basically, he's not more than very well be. He's going to be very well be, suspended. If you get suspended from the practice of law, right? And you go down here. This is the bar stuff. If you get suspended from the practice of law, okay, then it's very, very bad. You have to get off your cases. You have to close your office. You got to do all that stuff. And so here's Nick with his favorite thing in the world, an ambulance. Okay. And so it's a live disciplinary file. It's at the grievance committee. It's not at a local council. It's at the actual place. Now, here's the issue that we have. Okay. And I'll read my paragraph here. I call him Nicholas. That's what I do. I call him Nicholas. Nicholas filed a Rule 11 sanctions motion. Nicholas did against me because I raised these very issues to the Florida bar, which now says they have more than enough merit to be assigned to an investigating member and put before the grievance committee and probably the Florida Supreme Court. A lawyer should be able to use sanctions threats like jihad to cover up his own transgressions. And that's very true. That's what this guy said. This guy basically turns around and he calls me a terrorist, right? And he says that I'm extorting his client and that he asks for sanctions against me. And it's not sound familiar? Does anybody think that sounds familiar? Is there anybody else that we know that does things like that files motions for sanctions, and they had all sorts of stuff, and they file motions upon motions and sue people for no reason? Is there another lawyer that we've talked about before that's like Nick Chiappetta? Does anybody know who that lawyer is? I don't know. I don't know if anybody can think of one, but well, anyway. The fact that we have here is this. This man turns around and he says, and this is based on a situation where we had a conference and we had a settlement, and the magistrate judge, a guy named Nicholas Mizell, a very good magistrate, very nice man, very, very pleasant man, just a really good guy. He doesn't always rule for me. He sometimes rules against me, and I'm cool with that because I know I'm getting a fair shake with him. That's the most important part about the courts. Him and the judge that I have down there is Judge Dudek. He was appointed by the great Donald Trump, and I get a fair share with him. He has a great pedigree. He went to Antonin Scalia School of Law, so we know that he knows what he's doing with the law. And I feel like I get a fair shake in front of him too. He doesn't agree with me all the time. He's ruled against me before. But as long as I get a fair shake. Well, I'm in front of Judge Mizell with Nick Chiappetta and Danesh Noshirvan trying to resolve the case. And I told them, my case against you, and the basis of the case is that he called me on multiple occasions a child stalker, a sexual predator, a pedophile, all these terrible things. The same thing that Jeremy Hales said that he was called by John Cook and Michelle Preston. He used the pedophile trick, right? But he actually did this on his media, so I sued him. If you're a pedophile in the state of Florida, if you engage in sexual assault of a child under a certain age, you get the death penalty. We don't mess around down in Florida. That just shows that the people of Florida don't take this lightly, and so and with good reason. Sometimes the only thing that can cure these crazy bastards is a lead antidepressant. But he's grouping me in with those people with no evidence, no allegations, no claims. I'm a devout Roman Catholic, a member of the Knights of Columbus. I abhor any insinuation of any type of things like that there's any such thing as a child, a minor attracted person. I think that the people who believe that they're a minor attracted persons should get their head examined, okay, and maybe brought up on charges. But that's that. I'm trying to settle this case. The judge sat there with us for a day and said, let's settle. The case was pretty much settled. I needed $10,000. I said, I don't want that. Yeah, I want $10,000 from you to make this go away. It's the easiest money you're going to spend. What is Chiappetta right, Mr. Luthmann? Neither I nor my client will negotiate with a terrorist attempting extortion. You have a better chance of winning the lottery than you do receiving $10,000 from my client. Oh, okay. So a terrorist attempting extortion, a terrorist, I'm someone who's a journalist who's engaged in the court process, who did things the right way and went to court. Meanwhile, anybody who knows me means I don't have to go to court to get what I want from people if I really, really didn't want to. There are other quote-unquote natural law remedies, meaning I could go to the media and other places. I'm not insinuating anything untoward here for anybody who might want to put words in my mouth. But attempting extortion, a terrorist attempting extortion, right? Oh, then look at Joey Camp, 10K. I only settle for 600K. Well, you know what it is. In proper Trump, methodology, and in proper Trump fashion, it just went up. They just added another zero to that at least. So now it's 100K with Danesh, maybe more. I'm not trying to be a pig about this. I just want this case to be over. I want this guy to be out of my life. The only reason I'm doing this is because I think this guy is a bad dude. And I'm going to cover him because I think he's a bad dude. I think the public has a right to know about what a bad dude he is. But what does this guy do, right? He says you have a better chance at winning the lottery than you do receiving $10,000 from my client. In a court-supervised mediation. The mediator was the federal magistrate judge himself. So, look, this guy is terrible. This is what I showed everybody before, the video of Danesh. This is what he wrote about. Has Julian A. Jackson Fannin always been a demented pervert, allegedly, who hates his own people for a price? Julian A. Jackson Fannin is a reputed and very well-known civil rights lawyer, a great civil rights lawyer out of Miami. He was the president or the vice president of the oldest black bar association in the country, or definitely in Florida, the Miami Black Lawyers Association. And he was called a demented pervert who hates his people for a price, right? The misogynist told my wife that she didn't want to share personal information with him because he will share it with pedophiles, Joey Camp and Richard Luthmann, to harass her with. So he calls me and he calls Joey Camp a pedophile. This is just one place he did it. He called me a child stalker. He calls this. He called me a lot of other things. This is one of the bases for this. I have it in black and white. Pedophile Joey Camp and Richard Luthmann to harass with. So he's claiming that a reputable, well-known attorney, civil rights attorney, black civil rights attorney in Miami is a demented pervert who hates his own people. So he's saying that he hates his own race. And he says that me and Joey Camp are pedophiles. That's what he did. He put that out there, and so I'm suing the hell out of him for that. So this is a motion that was filed, okay, in the court. I'm actually this a little bigger. And this is the motion filed by, in another case called That Danesh Guy, which is Danesh versus Jennifer Couture. And this is a case that Danesh is bringing in Fort Myers. And in this case, Nick Chiappetta was exposed as making a fake email account, right? A fake email account of one of the lawyers on the case. I'm not kidding you here. There's a guy named Patrick Trainer. His email is PTESQ, right? PTESQ, right? And what did this guy Chiappetta do? He made an email account called PTESQ1@yahoo.com, right? Think about that. He impersonated another lawyer. You're a lawyer impersonating another lawyer. That's part of what's the issue here for Chiappetta. That's part of what he's going to the bar for. And this is the whole thing telling that not only did Chiappetta, right, he made a Yahoo email account. This is what he said. This is the best part about this, ladies and gentlemen, because if you're going to do something that is bad, an impersonation of another lawyer when you're a lawyer gets you disbarred. But if you're going to do it, at least make it hard for them to prove it. Nick Chiappetta told on himself. This is the dumbest idiot that ever lived. He's a worse lawyer, I think, than Randy Shotkin because of this. On June 30th, 2025, Trainer emailed Chiappetta to request a meet and confer. Chiappetta opposed the motion, but he admitted to Trainer that he, quote, made a yahoo.com email account in 2023 utilizing the email address ptesq1@yahoo.com. After the account was made, I never used the account, see below. Childish perhaps, but in retrospect, but I definitely nothing nefariously as you allege, right? But think about it, okay? He did that, but the problem is that this moron sent this on a motion, okay? He said he made it a long time ago. It's an open tab on the top of his tabs on his screen share, right? The open tab on the top of the screen share. That's what we got going on here. How do you have that if you made it once, you never looked at it, you have that open tab, right? And it has emails that he hasn't looked at, but he has some that he's read. He's caught in a lie. So he got caught, and then he lied to the other lawyer trying to do that. Okay? So this is Danesh, and I'll see if this can play. We'll see if the video plays here. I'm going to try it. If the video plays, let me know if the video is playing. I'll make it nice and big.
We need to find solutions here. Every major city in the U.S., Los Angeles, Portland, Chicago, New York, you need to start setting up left-wing militias to protect your communities. I'm not kidding. This needs to be coordinated. And you guys should all be in touch, too, across cities. We need organized left-wing militias. There are too many right-wing extremist militias putting us all in danger. We need to defend ourselves. We need to have a group of people that stand there, a well-regulated militia that stands there when ICE shows up, because nobody is holding them accountable. The people need to hold them accountable for when they go too far, for when they're not welcome. In fact, let me be honest with you, they're never welcome. They're never welcome. When ICE shows up in your community, a militia should show up right in front of them and tell them to leave. It is your right as an American.
Shortly after murdering Renee Good, ICE agents went to a local high school that was on lockdown and assaulted the students when they came out of class. This wouldn't have happened if a militia would have kicked them out of town.
Defend yourselves against Trump's personal pedo racist army. Fight back against ICE. Just because they're federal agents does not mean they get to violate you. They killed all that was good. Let's show them what's left.
So that is the person that Nick Chiappetta chooses to represent. He's a lawyer. He always had a choice to represent that guy. And this is a guy, everything he said in that video was either incitement, right? He wants police officers and ICE people and federal officers to get shot, right? Okay. He's inciting terrorism, right, Monica? He's inciting terroristic actions. The thing that he said at the end, even if it was, he tried to say he was a journalist. the stuff that he said at the end about the school was all a lie. He's telling people with guns to go to a school and shoot officers when nothing actually happened that he said there. He just wants places where officers are to be confronted by mobs of people with guns. How crazy is this, that this is in America, that this stuff is going on? The guy is a sicko, yes. You know the guy is a sicko when he changes his voice from film to know the accents, blah, blah, blah. That's right. He's an actor. He took acting lessons. He's a sick bastard. He does stuff. He talks to people. I'll play another one that's even better that will show you what a sicko this guy is, right? I'll play some more stuff. There's Nick Chiappetta with Danesh at the courthouse. This is them at the federal court walking out, avoiding the cameras because they don't want to talk about all the dirty deeds that they're doing. But let's see what else do we have here. I have this. Here it is. Does everybody want to see this one? I think Bearded wants to see this one. Bearded, this is Bearded's favorite Danesh video. So I will play this one, Bearded, because this is one that you like so much. Just let me know that you can hear this one.
Danesh, how long have you and your wife been swingers? Danesh, how come you admitted on the stand that you don't have 2257 releases for the underage woman that was in the video with you and your wife? How come, Danesh? Danesh, now's your chance to tell everybody. Danesh, where's your 2257 release for OnlyFans for your commercial pornography? How come you never filed that, Danesh? You have anything to say, Danesh? What do you have to say for yourself?
I don't like being near pedophiles. We get out here.
Dinesh, are you the pedophile because you didn't file the 2257 release for your OnlyFans page? Dinesh, are you a pedophile for not filing a 2257 release for your OnlyFans page to ensure that the talent was not underage, along with your wife? Do you and your wife have sex with underage women on camera for commercial pornography? Are you aiding and abetting this, Nick Chiappetta from Lake Worth, Florida? Are you aiding and abetting this, Nick Chiappetta from Lake Worth, Florida? Are you aiding and abetting child pornography? Are you aiding and abetting the creation of child pornography under 2257? Did you even go to law school, Mr. Chiappetta? What Cracker Jack box did you get it from? What Cracker Jack box did you get it from, Mr. Chiappetta? 2257 was put in to protect children. How come you're helping your client hurt children by not filing 2255 to 2257 releases under Title 18 of the U.S. Code? How come, Mr. Chiappetta? How long do you expect to keep your law license behaving like this, Mr. Chiappetta? How long, Mr. Chiappetta?
All right. So that is the sicko, Danesh Noshirvan, and his sick lawyer. His lawyer is a sicko too. Okay? His lawyer is a sicko too for represent. These are the people that Jeremy Hales is in bed with. Him and Randy Shotkin, he admitted, Jeremy, I'm with Danesh. The plaintiff there, we know everything that's going on. He's giving us all our secrets. He's our spy for us. Well, guess what? Your spy is a foreign agent for the Islamic Republic of Iran.
اصلا نمیخواد کمکت کنه میخواد بیاد روغنتو بدزده برش بامتم بکنه هر کیم بمیره اگه پسر خالت بمیره عمت بمیره مامانت بمیره میدونی چیکار میکنه میگه تروریست بودن حقشون بود بمیره همین کمک اینو نمیخوای با اینم تو رو کمک نمیکنه تنها چیز که واسه این مرد مهم هستش که چه عصبازی تو هپی میلش اومده امروز یا ببخشید چه عصبازی تو هپی میل ویکتیمش اومده بود ویکتیم نمیدونم چجوری فارسی بگم.
So if there's any doubt about who this guy is, right? If there's any doubt about who this guy is, he's going on the media in Farsi saying what a bad guy President Trump is. Right now we're in a battle against Iran. National security, everything else. People our soldiers are set that they're dying, potentially. They're putting themselves in harm's way if it doesn't go the right way. And he's a scumbag going out there in Farsi talking to people. I think, Helen, you're 100% right. He's got to be a foreign agent of some kind. And this is the person that our favorite person, Jeremy Hales, is in bed with. And so let me take this down for a sec. And I got to put some stuff up because the big thing that I want to show everybody today, and Joey, yeah, that's right? Jerm admitted to collaborating with them. Right, Mindy, you're 100% right. See, everybody who follows me and watches my show is very, very smart. I love how smart everybody is, right? Say, who else? Yes, he did, Mindy. That's true. He's not the bearded. He's not Mossad. Mossad is the Israeli intelligence. That's the other side. That would be the Iranian, the Republican Guard. So that would be a different group. Or there are foreign terror cells as well. So it's not Mossad. But the situation that we have, and I wanted to show everybody, is this. This is a formal demand letter. And I'm going to try and get a little bit closer and try to read it. Actually, there's another place I can get it from to read. I'm going to take this off. But this is from our friend, Mr. Joseph Camp. And Joey Camp actually has a lawsuit, and I talked about it with him a few weeks ago, and it got more, it's in a phase where there's all this more evidence got put in, and now there's a demand that Joey Camp made to Danesh Noshirvan related to both civil and criminal charges. And so let me show everybody what this is. Okay. This was sent, I believe, earlier today. Let's see. And bear with me, people. I just don't want everything in the right spot. So. Okay, here we go. I'm going to share this tab. This is being shared directly from my Google Drive. So everybody can see this. Right, I'm going to take this Joey Camp down, and then I'm going to share from this one. All right. Can everybody see this? This is a letter. Okay, I'm doing the letter here, and this is from Joseph Anthony Camp, Joey Camp. Right? Everybody knows Joey Camp. Okay. Let me see if I can get this nice and bigger for everybody. There we go. That's nice and big, right? Formal demand letter. Okay, that's what it says. Formal legal demand for settlement, Colombia and the United States. So he's sending this letter to Danesh Noshirvan, okay, whose address is known. I might have to block that out later, but it is what it is. We're on a live. I can't help that. And formal demand, April 30th, formal demand for settlement, public apology, retraction, copyright protection, content removal, monetary damages, dismissal of all legal actions. Dear Mr. Noshirvan, this letter constitutes a formal demand for settlement of all claims I have against you. Your false and defamatory statements, copyright infringements, and other wrongful conduct have caused me significant harm, including diagnosed PTSD, emotional distress, and related expenses. I am prepared to resolve this matter fully and finally without further litigation if you comply with all of my following demands in writing within 14 calendar days of this letter. My settlement demands are as follows. 1, public apology. You must issue a clear, unambiguous public apology for calling me a pedophile. The apology must be posted on every platform where you made or repeated the accusation and must remain visible for a minimum of 1 year. That's what I wanted too. That's what we had, $10,000 and a public apology with the same type of term. That's what I wanted from Danesh to make my case go away. Joey's, got more terms, but I was trying to just get rid of the case. You know how it is. So let's see the next part. Number 2, numero dos, public retraction. You must issue a public retraction in the same manner and on the same platforms as the original statements, expressly stating the following. A, I do not conspire with anyone in relation to you or any matter concerning you. B, I have never been paid to harass, stalk, or contact you. C, my disagreement with you stems entirely from the fact that after the epic breach, you offered me to, quote, do my best. D, I've never stalked your children. E, I've never stalked your wife. 3, acknowledgement of relative conduct. You must publicly acknowledge that your own conduct towards me has been far worse than anything I have ever done. 4, apology of copyright infringement. You must issue a public apology for stealing my copyrighted works. 5, permanent agreement not to infringe. You must agree in writing and publicly never to steal, copy, reproduce, distribute, or otherwise use my copyrighted works. 6, permanent freeze and removal of all content. You must immediately and permanently freeze, i.e. take down and cease all further publication, distribution, or engagement with any and all videos, images, recordings, multimedia files, comments, commentary, statements, or any other engagements about or concerning me, directly or by inference, or every platform and every format where they appear. This includes, but is not limited to, all social media posts, videos, live streams, articles, and any derivative content. 7, monetary compensation. You must pay me $10,000 per month for a period of 5 years as compensation for the PTSD damage I've suffered, together with the past and present related expenses. This totals $600,000 to be paid via certified bank check or wire transfer to a schedule we will all agree on final settlement agreement. Joey's wants the 6. I might have to raise my money, Joey. You know, I was at 100, I think. I added another 0. So maybe I have to go up a little more. I don't have to think about it. Dismissal of all legal proceedings. Upon your full compliance with all above, I will promptly withdraw the faute tutela and the singular currently pending appeal to the second instance. That is the tutela. That's the Colombian thing. And Danesh is in deep poo-poo. Dismiss the civil litigations against you in Colombia. Dismiss the 3 criminal cases currently pending against you in Colombia, one of which will be set for a criminal preliminary hearing at the same time. Another is set for mediation requiring your presence in person. Mediation requires you to attend in person, but without counsel, just you and I and the prosecutor. The other cases do not require administrative mediation and therefore arrestable offenses upon authorities locating you. And refrain from filing or pursuing the 2 civil cases currently being prepared in Denver, Colorado. Upon your written acceptance of all the above terms, we execute a formal settlement agreement and mutual release that includes a confidentiality provision, except for the public apologies and retractions required above, a non-disparagement clause, and a confirmation of dismissal of these legal actions. This offer is being made as required by Colombia law. And that's good because there was something in there that there's a criminal case and a civil case. And a criminal case and a civil case is a situation where you can't usually do that in the United States. In Colombia, the law is different. You can actually put all that stuff together. So it's under Colombia law. Okay, so Colombia law. So that's where we are. And Joey lives in Colombia. Yeah, Joey, can you go after them out here in the United States as well as Colombia rules of law? Yeah, he's a U.S. citizen and he's a resident of Colombia with all the protections of the residents of the Colombia. So he's got all that stuff. He can do all that stuff right now. So he's got what he needs to do over there. This is legally looking really good for Joey Camp. Okay, next thing we got. Offer being made in Colombia law is considered confidential data on the Colombia law made in good faith to resolve an applicable matter, the extent of litigation against you, saving us both time, money, and effort. So offer is made without prejudice, without any admission of any liability on my part. All rights are expressly reserved. It should be noted you are facing criminal charges for numerous offenses, including simulación de investigado o cargo, articulo 426, falso testimonio, articulo 442, injuria e calumnia, artículos 220 y 221, falsa denuncia, artículos 435 y 436, instigación a delinquir, artículo 348, concierto para delinquir, artículo 340, and many other offenses. Pardon my Spanish, it's terrible. You have 5 days from the date of this letter to accept these terms in writing. If I do not receive your full written acceptance by that deadline, this offer is withdrawn, and I will proceed with all legal actions and issue the first summons against you requiring your in-person appearance while contemporaneously pursuing the collateral matters such as the felony charges, which do not require mediation, and the civil matters, respectfully and amicably, Joseph A. Camp. And so that's what we have going on here. We have Joey Camp going after Danesh. And so, and there's Joey. I have affected entities in the United States, and this wants to be a global platform. He has to answer for the global reach. So that's what we have going on, is that this is the dude. Danesh is a bad dude. Danesh is in big trouble, looks like, in Colombia, on top of other places, the United States, where he's got lawsuits. And this is the guy that Jeremy Hales is in bed with, right? We got to remember, this is the guy that he is in bed with. So that's what we got going on here today. And it's pretty crazy, actually. It's actually pretty crazy stuff. And so that's where we started with this, with Danesh and with Jeremy Hales. They're both content people. They're both mega influencers. That's right, Monica. They're birds of a feather. That's what they are. And that was what the purpose of today was, to show how bad, the stuff that's happening with Nick Chiappetta, his lawyer, is, how bad the stuff is with the other lawyer, Randy Shockett, the attorney for Jeremy Hales. I showed ethical questions for both of them from the Florida. I hope the Florida bar looks at this, because the Florida bar is responsible. The Supreme Court of Florida is responsible for discipline. The Florida bar acts as the prosecutor when it gets there. We've seen impersonation of an attorney by Nicholas Chiappetta. We've also seen, look at this. I think Marla's making a phone call. She said she'll be right back. Are you calling the Florida bar, Marla? I think Marla might be calling the Florida bar. Anyway, but we have one that's in discipline right now in Nicholas Chiappetta, very serious discipline and serious criminal impersonation and serious. And I didn't even talk about the stuff. Maybe we'll do that tomorrow about what Chiappetta did during the deposition and what caused Judge Steele to file or to write an order admonishing him in federal court. We have Chiappetta acting that way. We have Randy Shotgun acting that way. And so these very, very bad mega influencers cannot get this far, cannot do this court stuff, cannot bring all these court cases and make them into content unless they have lawyers that are co-signing. That's what we have here. And so these lawyers are officers of the court. They're officers of the court in Florida, of the federal court. They're officers of the court. If the judges want to get angry that this content is happening, the people they have to get angry with are the officers of the court, not us, the general public. We're out here in the media. I'm a journalist. We're people that watch the media. We watch what's put in front of us. We have every right to see it. We have every right to talk about it. We have every right to do anything. When you're a lawyer, you don't have First Amendment rights anymore. You've traded your First Amendment rights for the privilege of practicing law. So if you have Shotgun with the privilege of practicing law and Chiappetta with the privilege of practicing law, then we're in a situation where, they have to answer to the courts more than we do. Before we do, the courts could call them in because they're lawyers, right? So, I've gone already for an hour 40. I usually try to get done in an hour and a half. So I'm going to be going in a few minutes. So I'm going to finish up today, but I'm going to try to get on tomorrow. Let's see what time I can do. I'll probably do it a little earlier, maybe noontime, 1 o'clock. I'll get on, and then put it out there. I'll give like a notice about at least 45 minutes to know when I'm going to go on, and we'll talk about more of this stuff about Jeremy Hales, about Randy Shotgun, about Nick Chiappetta, about Danesh Noshirvan, about cancel culture, and how they milk these courts. I'm going to put some. The big one I didn't put up, and that's what we'll close with today. We're going to do closing today with the let's see. This is what I wanted to put on, actually, and it's a good thing I remembered to put this on. Is this it? No, I already did that one. Let's see. Here it is. This is a notice of filing. We just talked about the notice of filing before in the other case, right? We talked about the notice of filing in the Fed 2 case with Jeremy Hales. This is a notice of filing in the Danesh Noshirvan case that I have in the Middle District. Okay, and I'm going to read this. It's very short. It's only a couple of pages long. Plaintiff Richard Luthmann, proceeding pro se, files this notice of filing and states, plaintiff hereby files the attached email correspondence dated April 16th from plaintiff to defendant's counsel Nicholas Chiappetta concerning matters directly related to the conduct of this litigation. Attached email is filed for the person making the clear record of plaintiff's position regarding plaintiff's counsel's failure to confer in good faith required by Local Rule 3.01G of the Middle District of Rules of Florida. Plaintiff's concern regarding counsel's treatment of plaintiff in a manner inconsistent with the governing standards of professional conduct and civility as per the local rules, the civil action order, and incorporated attorney standards and the rules of professional conduct. Local Rule 3.01G provides that before the filing most motions in a civil action, the movement must confer with the opposing party in good faith in efforts to resolve the motions. The rule further reflects a certification stating whether the parties agree and if the motion is opposed, explaining the means by which the conference occurred. The rule also contemplates sanctions rule contemplates sanctions for purposeful evasion of the communications. As Judge Dudek has explained in his published procedures, the term confer requires a quote, a substantive conversation, quote, an exchange of ultimatums by email or by letter does not satisfy the good faith conference requirement. That's Judge Kyle C. Dudek, Civil Case Procedures, Motions, Local Rule 3.1, Middle District of Florida. So Judge Dudek has my case. He was appointed by President Trump. He's a good judge. He's just a new judge on Article 3, but he was a judge before that as a magistrate. And he went to Antonin Scalia Law School. So when he says something, he pretty much knows what he's talking about. The Florida rules of professional conduct likewise require that a lawyer make reasonable efforts to expedite litigation consistent with the interest of the client. The rules regulating Florida Bar 3.2 A lawyer may not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. A lawyer may not engage in conduct in connection with the practice of law that is prejudicial to the administration of justice, including to knowingly or through callous indifference disparage, humiliate, or discriminate against others on a basis that includes disability. In addition, Florida's professionalism standards expressly recognize that lawyers owe opposing parties and counsel fairness, integrity, and civility in written and oral communications. This is the pledge. When they do an oath of admission, the goals of professionalism. To opposing parties and their counsel, the parties, I'm a party, I pledge fairness, integrity, and civility, not only in court, but also in all written and oral communications. That's the Florida guideline, right? Like he says that I'm a terrorist committing extortion. Is that the Florida guidelines? Does that say fairness, integrity, and civility when he calls me a terrorist and extortion? Well, that's the issue we have here. That's the issue. The attached correspondence speaks for itself, and I'll read that too. The plaintiff files it so the court has a complete and accurate record of parties' communications bearing on conferral, litigation, and professionalism arising in this action. So here's Exhibit A, and that's Nicholas Chiappetta. I'm going to go all the way to the bottom. And this is what got filed, okay? Nick Chiappetta did a notice of filing on 4/14, right? So that was on 4/14. Now, I get emails from the Middle District of Florida. The email notices when something's filed. I see what's there. This is the whole filing. I see what's there. I don't get this from the Northern District. They don't send me emails because I don't know why they don't send me emails. I guess they just don't like me. They think I'm a subhuman or less than a person or something. I don't know. I'm going to have to ask judges and the clerks why they don't like me, whether it's a biased reason or it's another reason or it's an oversight. I don't know. So here's the situation. I write him back in true Luthmann form. I copied a lot of people there too. So, hey, Nicholas. That's my name for him. I call him Nicholas, right? Oh, and Lisa's here. Lisa Lee. What is that? Hey, Lisa Lee. Well, since Lisa's here, I'm staying for a bit longer. The dogs are going to have to wait. Lisa Lee is here. That's great. And so, yes, Lisa Lee is here. Hi, everybody. We have a special guest star. So, Lisa, I'm trying to get on the Jeremy Hales totem pole. I'm not going to get above you or Bruce, but I'm aiming for number 3. I really am. You know, I know that you and Bruce are going to be 1 and 2, but I'm aiming for number 3. That's what I am. So this is against to Nick Chiappetta. Hey, Nicholas, I love the filing copied. How is Danesh and how is Akram, aka Helen? How is the Ayatollah? He's not doing so well. The dead one and the one with ED. Well, I guess they both technically have ED now, don't they? This is Akram Noshirvan. If you can see here, Akram Helen Noshirvan is Danesh Noshirvan's mother. She is a naturalized U.S. citizen. Naturalized U.S. citizen. But you saw what her son does. A few people already think that he's an agent of a foreign country. Well, if he's an agent and he affiliates with Helen Akram Noshirvan, you'd have to question whether this naturalization petition was filed in good faith and whether the naturalization of his mother was not fraudulent. So I've done this and others, I think Joey Camp might have done it too. We sent this as good citizens over to Tom Homan and the border czar, and sent it over to Mark Wayne Mullen, who's now the DHS director. And I've sent it to a few other people who are in Trump's circle to get this in a situation where it's reviewed. I think we have to actually review this person's allegiance to the United States of America, especially when we have our servicemen at war, basically, with Iran. Our boys could be killed. Who is this person, Danesh Noshirvan? Who is his mother? Are they a terror cell that's just been sitting here waiting? Because it looks like it's a terror cell. And Joey says he snitched to everyone. All right, Joey. As we speak, and I'll tell you, this is very clear, I am actively engaging with the political branches of government to advocate for the prompt enforcement of federal immigration law. This conduct falls square within my rights as a private citizen under the First Amendment to the United States Constitution. The extrajudicial activity I reference consists of lawful petitioning, political advocacy, and engagement with elected officials, activities that are not only permitted but expressly protected. The 11th Circuit has repeatedly recognized that core political speech, right? Oh, I covered it up. The core political speech and petition activity lie at the heart of the First Amendment protections. Keaton versus Anderson-Wiley. Okay, they can have no restriction on speech on matters of public concern and petitioning the courts on matters of public concern. Moreover, the right to petition the government for redress of grievances is independently safeguarded and extends to efforts to influence the legislative and executive action. So Smith versus Arkansas State Highway Employees. It's a Supreme Court case. Also Kate v. Oldham, 11th Circuit case. The 11th Circuit has also made clear that government actors may not penalize or chill individuals for engaging in such protected activity. Retaliatory conduct would deter a person of ordinary fairness from exercising First Amendment rights. It's actionable. You can't do that. Accordingly, my engagement with policymakers and public officials regarding immigration enforcement is constitutionally protected conduct, is not improper, prohibited, or sanctionable extrajudicial activity, but rather a lawful exercise of fundamental rights guaranteed by the First Amendment of the Constitution, consistent and upheld by binding 11th Circuit precedent. I also thank you for admitting that this matter and the Noshirvan versus Couture matter, the 1218 case, squarely has a political component. I guess that your bullshit motion in limine to keep your client's political diatribes and allegiances out of the 1218 case should be denied. So that bears me a couple of seconds to talk about that. Danesh is going to trial in the 1218 case. And he filed what's called a motion in limine to exclude evidence like I just showed. The evidence of him talking in Farsi, the evidence of him calling Donald Trump this and that, the evidence of telling people to shoot ICE agents. And a lot of it's related to the fact that the videos that he made that are the subject matter of litigation have a political component to it. One of the people in the video is in a mask dressed as Donald Trump. And he starts putting Donald Trump pictures up on the screen in those videos. Well, if he's brought Donald Trump in those videos, then Donald Trump should be in for all purposes. So the motion that he made to the judge saying, oh, keep his politics out of this, has nothing to do with it, is pure and unadulterated bullshit. So I told this to Chiappetta, to Nicholas. You basically just said as much. Please explain to Danesh how this filing made the, quote, irrelevant statements about his Iranian anchor baby status, because that's what he is. His mother was naturalized because he was an Iranian anchor baby, and many other things squarely relevant. Explain to him how you, Nick Chiappetta, opened the door. Maybe he shouldn't pay this month's fictional hourly bill because he claimed that this guy pays hourly bills. This guy doesn't pay hourly bills. You know, this guy is, it's crazy. So attorneys press Sinfen, Cincinnati Financial Company, or the Cincinnati Insurance Company. That's his mark. They want that company to pay a $2 million insurance policy out, but it's not going to happen. And the Florida Bar, they were copied on this. Because this is a bullshit case. And to do that, you'd be giving money to a foreign agent. You know, I don't know how a financial company would do that that's publicly traded, that would do that, and they would agree to give money out to this person. So I said, please run back and file this email with the court as well, or else be prepared to say why you didn't want a complete record. So he didn't want a complete record. He didn't run back and file it with the court, right? And then what happens? I filed it with the court. That's how I'm good like that. Monica, if he doesn't like our country, he should leave. I agree with that. I agree. If he doesn't like America, if he wants to say how bad Trump is, if he wants to go in Farsi and say this, that, and the other thing, there's plenty of other places you can go live. I'm not saying go back to Iran. If you want to go back, maybe that's where your mom's going to get deported to if she ends up getting deported. She'll have to go live in Iran. The other choice is that she can hang out in immigration jail until they figure out if Iran, they can go back to there. Or there's plenty of other countries you can go to. You can go to like Somalia or Chad or one of these places that's like, you know, terrible. You know, one of these real shithole countries. You can go anywhere you want. You don't have to stay here if you don't like it. Nobody's making you stay, Danesh, you know? So please run back and make this blah, blah, blah. I'm concerned your conduct reflects discriminating against me on the basis of my known mental disability. Now, we talked about my mental impairments. I have a judge in New York that said, and he's one of the best judges, he wrote the book on evidence, Weinstein on Evidence, and he made an evidentiary finding about Rich Luthmann that says, I'm batshit crazy when it comes to the ability to render sound legal judgment. He says that my opinions, my thoughts are absurd, bizarre, absurd, and ruthless. And he said that any advice that I would give, because of my mental defects, does not rise to the level of good legal advice. That includes to third parties, and it includes to myself. I can't give myself good legal advice. So I'm allowed to do what I do. I have a First Amendment right to do it, but I'm not constrained by the First Amendment the way the lawyers are. But the lawyers are constrained, right? And so Nick Chiappetta has to treat me the right way, but he doesn't do that. Under 11th Circuit law, disability includes a mental impairment that substantially limits major life activities, as well as a record of such impairment or being regarded as having such an impairment. Well, I think a federal court judge's opinion is a pretty good record, right? That's a pretty damn good record. 11th Circuit likewise recognized discrimination includes adverse treatment tied to known physical or mental limitations, and that the law protects individuals from actions taken because of disability rather than some genuinely neutral basis. Well, Nicholas, please tell me why you're treating me the way you're treating me. Because if it's not a neutral basis, I think it's a discriminatory basis and it's actionable, right? So I don't know. In light of that, any disparate treatment of me because of my confirmed mental disabilities raises serious concerns of unlawful disability-based bias by an officer of the court named Nicholas Chiappetta. He's an officer of the court. Such conduct is also consistent with the Florida rules of professional conduct, prohibits a lawyer from engaging in conduct that's prejudicial to the administration of justice, manifests bias or prejudice based upon disability. That's Rule 4-8.14D. At a minimum, the conduct raises substantial concerns that the professional obligations have been violated. He may not have broken the law, but he sure as heck probably violated the professional conduct. So are you taking advantage of me through my known disabilities? Why won't you accommodate me? And I closed off what I said. I hope we're still friends, Johnny Ringo. Because I thought, Nicholas, if I thought you weren't my friend, I just don't think I could bear it. So that's where we are with Mr. Nicholas. So on that note, it's almost 4:30. I'm on a lot longer than I wanted to be, almost 2 hours. But I'll be back tomorrow. I'm going to be doing this hopefully every day, and talking about Danesh and talking about Jeremy Hales, talking about these cases because they want to make content out of it. I'm going to do law and content and journalism and everything else on top of it. And they're going to understand what it's like to have a content factory. I'm going to turn it around on them and do what I got to do. So I'm in this for about an hour, 57 minutes. I'm going to say goodbye to everybody. Okay. And, I think that everything here speaks for itself. I'll be putting out more articles on this. If you have any questions about this, let me know. I'll be back on the chats, and I'll probably try to be in everybody else's chats too when I can stay up late enough. Sometimes I'm like a little, I turn into a pumpkin. It's like Cinderella's ball, and I turn into a pumpkin at midnight sometimes, or 10 o'clock even sometimes. So I will get this, and I have some stuff to do. It's 4 o'clock, 4:30. Let me go do my errands and my things, and I will see everybody again soon. Take care. Love you all. Bye-bye.
The Ayatollah is paying me. That is right. We have an agenda to turn America into Sharia law. You will see Hazar